Hello and welcome everyone to this month's Family Law Hour. So glad that you could join me today. I'm excited to get into our topic. We're going to be talking about custody and how, if the court has to decide what a custody schedule might look like, what do they consider? So we're going to jump right in and go over a few clarifying things. So Colorado courts don't usually call custody. They refer to it as the allocation of parental responsibilities, which is a big mouthful, but is essentially the same thing of what we sort of normally refer to and think about as custody. And as you go through the process, you may find that the court does things like that. Like they use words that we don't normally use in everyday life, or make things seem more complicated than maybe they are just by the language that they're using or by the process that is used to determine a custody order or a parenting time schedule. And that's pretty common, right? And even getting basic information about the legal process can sometimes be really challenging. It's not a simple process most of the time. It feels very complex, and it's often not something that most of us have encountered in our daily lives. So if you don't sort of know what to do or where to find some answers, I'm glad that you're here today. Hopefully we can answer some of them for you. But that's one of the reasons that I started this Family Law Hour, to give you that information and to hopefully simplify the process just a little bit. So I am Lauren. I'm an attorney here in Colorado. I practice family law exclusively. I help folks break up for the better. And I really just don't believe that people should have to drain their bank accounts or bust the bank to go through the legal process to either break up or to establish a custody plan. And believe me, I've seen people pay a pretty good amount to do just that. For divorces in Colorado, the average number I've heard floating around for a bit is $15,000 when you have an attorney involved, and that's usually per party. I've certainly seen folks pay even more than that and not get to the finish line, which is really just heartbreaking, and I just don't believe should be the case. So if you are agreeable, if you're cooperating with your other co-parent, whether it's in a divorce or just a custody case, you're really trying to be reasonable and do the right thing. You're trying to follow the process. I just don't believe that you should have to break the bank to do that. So that's why I'm here, both for this free Family Law Hour and in my practice. I tried to provide that down to earth advice so that you can go through the process, make it a little bit more simple, and hopefully get to the finish line. So that all being said, every case is different. While I practice in family law and certainly have seen a lot of similarities between cases, every family is absolutely unique and deserves to have the special attention and detail paid to each individual case. So today I'm just going to be providing information about the custody process, what the courts look at, what they consider if they are the ones who have to make the determination of what a parenting schedule should be and how major decisions should be made. But if you have specific questions about your case, your particular situation, do make sure that you reach out to an attorney and talk to them. You want to get specific advice on your situation, likely before making any big picture decision. So nothing I say today should be taken as advice for your particular situation. Please do contact an attorney if you have questions or want some guidance on your particular circumstances. With that being said, let's jump in and talk about how custody is determined. So as I mentioned in the beginning, we usually call it custody. Some other states may refer to it as legal custody or physical custody. In general, they're kind of talking about the same thing, but here in Colorado, it's important to understand what language is used so that you can understand when it's used in your case, what they're talking about. So custody is generally under the umbrella of the allocation of parental responsibilities. So that term, parental responsibilities, covers both custody, so who physically is in care of the children, where are the kids physically during a certain schedule, and decision making, so who makes major decisions about the children. That sometimes in other states is referred to as legal custody. So sort of what school they go to, should they have elective surgery, major medical decisions, religious decisions. Those are the two aspects of parental responsibilities, right? So we have the parenting time and we have decision making. So you'll hear me use those terms throughout our time together today, and that's what I'm talking about. So just so you know. So one of the common misconceptions that I hear a lot is that Colorado is either a mom state or a dad state, or usually not a dad state at all. So that is not the case at all. Colorado is really a kid state. And that is because what the courts have to go to consider and the factors that they have to go through when they are the ones deciding what a parenting time schedule should be or how decision-making should be allocated. They are looking at what is in the best interest of the child. So we're going to kind of go through those factors, and I'll give you some information and try and give some general examples of what might fall under each of those factors that the court might consider. But again, this is going to be highly specific to your particular situation, your kids, your living arrangements, the environment, all of that. So again, this is just informational so you can kind of get a sense of the structure that the court is working in so that you can then apply your own particular facts to that structure. So the first factor that the court is going to consider is going to be the wishes of the child's parents as to what parenting time should be. So that's pretty straightforward, right? Mom wants week on, week off. Dad wants every other weekend. Dad wants mom to have summertime because she lives in a different state. Mom wants the kiddos to be with her. Right? Whatever it is, it's the wishes of the parents in terms of parenting time. And you'll have to, in your situation, provide why you wish for those things. And then secondly, the court is to consider the wishes of the child if the child is sufficiently mature to express a reasoned and independent preference as to the parenting time schedule. So first thing with this one is there's no age, as you can hear me just say, right? I didn't say if the child is over 12 years old, the court will consider his or her preference. The standard is the child sufficiently mature to express a reasoned and independent preference? So this is a very vague, squishy term. There's no bright line rule in terms of an age. So this can be argued, right? There are some very mature 8-year-olds and there are some very immature 15-year-olds, right? So it all depends on your situation. So the court will consider it if the child can make a reasoned and independent preference. However, the trick with this is normally the courts are not going to allow children to testify. There are exceptions. Certainly every case is different, and it may very well be happening in your case or be allowed in your case. But in general, the courts don't want to drag children into the middle of a parenting time or custody dispute between the child's parents. So while this is a factor, it's usually hard to get that information in unless you are using the resources of someone like a CFI or a child and family investigator who has actually spoken with the child. So while, yes, does the court consider what the child wants? Yes, but there's a big asterisk on that, that it's actually pretty hard to get that information into the court. So next, what the court is going to consider is the interaction and interrelationship of the child with his or her parents, siblings, and any other person who may significantly affect the child's best interest. So we're really looking at kind of what is the nuclear immediate family of the child and the extended family, right? Does one parent live with their parents? So does the child live in a multi-generational home, or does the grandparents are often provide childcare? So kiddo sees them, every day after school because they come to pick them up. Maybe one parent has her whole family here or his whole family here, right? And so they get together all the time. So the child has relationships. If they have siblings, certainly the court is going to want to hear about the relationship with the siblings, whether they're full blood, half blood, siblings that are not by blood at all, but just by choice. So the court really wants to understand sort of what those important relationships in the child's family look like, and how they interact, how frequently, all of that, what that looks like. Next, the court considers the child's adjustment to his or her home, school, and community. So again, we're sort of looked at family members just then. We're going to take it a little bit further out and consider, what the child's life has been like. If they live here in Colorado, have they always lived here? What school do they go to? How long have they been in that school? Do they live in the same community? Do they have a bunch of friends in their community? Are they in theater? Do they play sports, right? So just sort of all of the factors of the child's life, both in his or her home, school, community. What does that look like in the child's life? That's something that the court is going to want to consider, because that's a big factor in figuring out potentially a parenting time schedule. The court will probably not want to entirely disrupt what the child's life looks like, right? A divorce or a breaking up of parents is hard enough. And so if the court can fashion a parenting time schedule together that sort of keeps that environment, that community around the child, they're going to try and do that. So they need to know what that is to be able to make that decision. Next, the court considers the mental and physical health of all the individuals involved, except that a disability alone is not a basis to deny or restrict parenting time. So just because one parent may have a disability, that doesn't automatically mean that they shouldn't get any parenting time. But the court does want to consider what the mental and physical health is of the parties, of the parents usually, to determine if they are physically able to care for a child, especially, if they do have a disability and they are unable to properly care for an infant. Maybe that's going to be a consideration. That's not a bar into the future, right? An infant grows into a toddler, to a child, to a teenager. So this is not a bar forever, but the court certainly wants to know if there is anything to be considered there. That's a factor that I will say is probably not as common in most cases. Most of the time, although you may not agree with your co-parent, you may not think they're the best person in the world, usually the mental and physical health consideration isn't a factor, because both parents don't have any issues that anybody needs to be worried about, at least when it comes to their ability to parent. So next, the court is going to consider the ability of the parties to encourage the sharing of love, affection, and contact between the child and the other party. This is a pretty big one. There is a caveat in the statute with regards to abuse. So if the one parent is not encouraging contact with a party because there is a history of abuse, or there's a domestic violence concern, then certainly that is an exception and a reason to withhold contact. But in most cases, that's not present. And so the court really focuses in on this when they have two parents who are either divorcing or have broken up, is how is each parent encouraging the child to love and care for and have affection for and have contact with and interact with the other parent. And this can sometimes trip some folks up because, quite frankly, they're just not doing a great job at that. And that's really something that you need to consider. So as we're going through these, outside of that first factor of kind of the parents' wishes, you can see a lot of these focus on what's best for kiddo. And in most cases, what's best for kiddo is going to be a relationship with both of his or her parents, regardless of how the parents feel about each other. If there's, you may not think that dad is a great dad at all, but that's, really not a judgment for the court to make. The court wants to know that dad is, or mom is ready, willing, and able to show up as a parent. And you as the other parent, are you encouraging that relationship? So that is one thing that the court's going to look at. They're also going to consider the past pattern of involvement and whether it shows that the parties the party's past pattern of involvement reflects a system of values, time commitment, and mutual support as it relates again to kiddo. So again, those last two that we talked about are pretty similar, right? So looking at the pattern of behavior, are you encouraging a relationship? Are you showing up for your parenting time when you have it? Are you spending quality time with the child? Are you reflecting a system of values? Are you giving mutual support both for the child, right? Is everybody on team kiddo? That's what the court's going to be looking at, and whether the pattern of behavior is going to reflect that, right? Because words are okay, but actions are certainly going to speak a lot louder than them. So the last two here is the physical proximity of the parents to each other, and sort of how that logistically and practically relates to parenting time. So if you have parents who live on opposite sides of the state, week on, week off is probably not going to be a very realistic parenting schedule, because that's just a lot of transportation. Kiddo is probably enrolled in school in one location, so they can't be bouncing back and forth. So the court is going to want to understand the physical proximity to of the parents to each other to determine what a parenting time schedule would be that's actually practical and is not going to be a huge burden on everybody, right? Nobody wants to be in the car for hours at a time. That's not quality time with either parent. And then lastly, the court looks at the ability of each party to place the needs of the child ahead of his or her own needs. Again, this is all about kiddos, right? So we're not a mom state, we're not a dad state. We're not going to assume that because one parent is a mother that somehow she's a better parent or should have more parenting time. The court actually can't consider those kinds of things. What they do want to consider is what is in the best interest of the child, and the parents showing that even though maybe that other parent is not their favorite person in the world and they don't really want to be around them very often, but man, their kid loves them because it is their other parent. Can you put the child's needs first? And that means a lot of sacrifice, right, by parents. But the court is going to want to see that to determine whether the parents are acting in the child's best interest. And that really informs the court if the parent is showing that they are doing that, putting the child's needs in front of their own in every possible way, even down to the smallest details. Then when that parent maybe says, I think that it's best for my child to have this schedule, it carries a little bit more weight, right? Because the court can see that the parent isn't just saying something of what they want, what they selfishly want to see, but really what's best for kiddo. So those are the factors that the court is going to consider if they have to make the determination of a parenting time schedule. So this is in the event that the parents can't reach an agreement on their own. They just can't see eye to eye. And so the court has to determine, okay, starting, at this point in time, where is kiddo going to be when? What is that physical custody, that parenting time schedule that's going to happen? So if the court also has to make the determination on that other aspect of parental responsibilities, right, decision-making, major decision-making, the court considers all the factors that we just went through and then 3 additional ones to determine how major decision-making should be allocated. So usually there's 3 categories that we cover, which is education, religious, and medical, kind of major decisions in those categories as they relate to kiddo. It's becoming more and more popular that extracurricular activities are also being included in the categories. So we sometimes will do 4. And these are major decisions. So this is not day to day, what time do they do homework? What time does kiddo go to bed? Does he get to watch TV after he does homework, or maybe a little bit right after school? What does he eat for breakfast in the morning, right? It's not those day to day decisions, although the court certainly encourages parents to work together so that there's somewhat of a consistency between different houses. But those day-to-day decisions are going to be based with up to the parent who has kiddo at the time. We're talking about major decisions. So for education, what school should they attend? Maybe if there's a child who needs an IEP, what the decisions in that space might look like. Medical decisions, so possibly could they have braces, or if they need an elective surgery, is that appropriate? Major medical decisions. And it really helps encourage both parents to be involved, even in the maybe between day-to-day and major. So, child well visits. Those may not be major life events, but we want both parents to be involved, right? This is something that's happening in kiddo's life. Maybe the doctor, brings up something that, hey, you might want to think about this. Maybe look out for this. Maybe get kiddo some additional resources regarding this, concern or thing just to be aware of for kiddo. That's not a situation that we want one parent to be in the dark about, right? We really want both parents to be involved because that's usually what's going to be best for kiddo. But in terms of major decisions, when those decisions are made, there's usually two options, which is they're made together, they're made jointly, or they're made by one parent, so sole decision making. The court has sometimes done them all the same. So religion, education, medical, extracurricular are all joint. Sometimes they do all sole, although that is pretty rare. The court, again, doesn't like giving decision-making just to one parent outside of some strong circumstances, because it usually means that the other parent is not involved and they don't want that to happen. And sometimes they'll sort of mix and match, I want to say. So may do joint decision-making for medical and religion, but education is with one parent. Sometimes they'll do a tiebreaker, so the parents are required to discuss the decision together. But if they can't come to an agreement, then maybe one parent kind of has the final decision. So there are some ways that they can get creative, but really at the end of the day, they do want to encourage the discussion between the parents, because that's what's going to be best for the child. So in addition to the factors we just went over, when it comes to decision making, the court also considers a few things. So the first is whether the parents can cooperate and make joint decisions, right? Or if these are two folks who can't be in the same room, can't stand each other, every time they even, ask what time of day it is, it blows up into a big argument. That's probably not a great situation to have those parents do joint decision making, right? Because most likely not a lot of productive conversation is going to happen. So if there is a pattern of behavior or a history that the parents can cooperate and make decisions together, again, doesn't mean you love each other. There's probably a reason that you've broken up or are getting divorced, but can you civilly talk about major decisions that have to do with your child? Then that's a positive support for joint decision making. The court will also look at whether the party's past pattern of involvement shows an ability to make joint decisions, which provide a positive and nourishing relationship with the child. So again, looking back on, have you shown in the past that you are able to make joint decisions that create a positive and nourishing relationship with kiddo, both with you individually as a parent and with the other parent. Can you show that you're able to do that and that you have been able to do that? And if both parents can show that, another good support that joint decision-making is probably appropriate. And then lastly, the court's going to look at whether joint decision-making would promote more contact between the child and each party. So again, really you can see here that the focus of the court is maintaining, building, establishing, continuing relationships for the child with both of his or her parents. That is usually what's best for kiddo. And so if having both parents involved in joint decision-making means that both parents will be more involved with kiddo, right? Especially as kiddos get older and we start to talk to them about, hey, what sports do you maybe want to play this year? Or, it's time to go to high school. What are you thinking about? Is that something that now it can almost be a three-way conversation, ideally with both parents and kiddo at the same time, but maybe it's, son talks to mom and son talks to dad and mom and dad talk to each other. Is that joint decision-making ability going to encourage that relationship where there's more open lines of communication? So if the court finds that that's likely the case, then most likely they will order joint decision-making. So those major decisions will be made by both parties together. So those are the factors that the court considers. As you can probably tell, there's no bright line rule. It's not black and white. There's a lot of gray. There's a lot of discretion, quite frankly, that the court has. And because every family is different, we need a bigger space to be able to consider all the unique and individual characteristics of each child, of each family, of both parents, to determine what's best for that child, right? It's not a one size fits all, and nor should it be. So there's no bright line rules, which makes these decisions pretty difficult sometimes, because usually both parents have some pretty good arguments. They have some pretty good cases that they're presenting, and the court often, says, I agree with both of you in a lot of respects, and I disagree with both of you in a lot of respects, right? And so it really makes for a hard decision, and because of those more general open terms, because we want to allow the court to make individual decisions for each child. So if the parties can't agree, the court will make the decision about what a parenting time schedule should be and what joint decision-making may look like. They do consider those factors. What the court cannot consider is any conduct of the party that does not affect the party's relationship with the child. So if you're in a divorce, for example, and there has maybe been some infidelity, if that conduct of one of the parties does not affect the party's relationship with the child, the court cannot consider it. So as much as you may want to bring it up because, yes, that parent was a total jerk, the court can't consider it because it doesn't reflect the relationship of that party with the child. Other things that are kind of along those lines are maybe how much money each parent makes, or what their religion is, or how much education they've had, or maybe even just a parent, the fact that he or she is in therapy right now. Again, if it doesn't affect the party's relationship with the child, the court cannot consider it. And one of the things too that is pretty explicit in the statute is the sex or gender of the parties. So we're not a mom state. We are not a dad state. The court doesn't really even think about that. They can't consider that. What they can consider is what's in the child's best interest. And to be able to determine that, we have a number of factors that we just went through. So if you are in the middle of a custody discussion, hopefully not dispute, but a discussion with your co-parent, whether that's in the space of a divorce or this is someone that you weren't married to, but you are trying to figure out a custody plan or a parenting time schedule going forward. If you are able to reach an agreement, that is going to be the best for everyone involved. I can usually tell most people that if the court makes the decision, no one is happy. Neither parent is happy. And so if you're kind of forced to do a schedule that you didn't really pick, that kind of just leaves everybody, at the starting line and not in a great mood. And, they're just begrudgingly doing something. And that's not what we want, right? Our kids are feeling that. They feel all of it. And so if we can remove that because the parents have worked together and they've come up with an agreement and everybody's like, yeah, do I absolutely love every aspect of it? No, because there was a compromise, but can I live with it? And do I think it's best for my kid? Yes. We just feel a little bit better about actually having to live in that parenting plan. So if you can do that and reach an agreement, you're going to keep control of the outcome. You're going to have a say in what the parenting plan is. And you can find a parenting plan form and kind of all of the parts of that. So school year parenting time, summer parenting time, holidays, things like the child tax credit and child support and how decisions should be made, how extracurriculars should be paid for, right? All those kind of details that go up under parenting. Those are in a parenting plan, and you can find the court's general form for that on the court's website, which is www.courts.state.co.us. They have a parenting plan form on there. It is generic. And so again, every family is different. So if you need some additional guidelines and boundaries in your parenting plan, you can add them. If it's something that you're just finding that form is just not quite working for you, and it would be helpful to have someone draft it individually for your particular situation, you can hire an attorney to just draft your parenting plan to make sure that it includes all of those details and nothing is left out. So the process in Colorado is designed that you can do both divorce and custody on your own. What I generally find, though, is at some point, most folks have questions, especially when we start getting into, well, what's in the best interest of the child, right? Because it's not black and white. Everybody says, well, what about this? And my kid needs this. And my other parent did this. And right, if you're in that situation and you just need some specific help, like I mentioned at the beginning about your particular situation, that is when you want to talk to a lawyer and get some specific advice on how it's best for you to go forward. So if you can do it and you agree with your other co-parent, you can complete the divorce or custody process for less than $500. And most of that cost is going to be in the fees that the court assesses. So when you file the case, there's a fee for other, depending on if you e-file or you file electronically, there's a fee for that. But if you can only incur the fees that the court is going to have no matter what, and you don't have to involve lots of lawyers and lots of litigation and lots of disputes, then you can certainly complete the case for less than $500, which is pretty budget friendly. Additionally, if you would just like some more information about the process, words like this, sort of, talking or learning from someone who is speaking in more normal everyday terms, kind of breaking it down and making the process less complex. Then even within that $500 budget, you can still get that information in that guide through the process of every form you need, what to consider for each form, what those factors are that the court is going to look at in Law Guides, which is at colawguides.com. This is for less than $25 a month. You can get the step-by-step instructions to complete both a divorce or a custody case in Colorado. Go through the entire process yourself. You'll have all the information that you need, all the forms that you need linked right there, so you don't have to go scouring the web for them. Some video tutorials, just all the information that you need to get your case finished. You'll save a lot of time, money, and frustration trying to figure it out on your own. It's all right there, and it's all for less than $25 a month. You can use it as long as you need it. So if that would be helpful, please do check that out. If you're thinking that your situation needs some additional guidance from an attorney, I do also offer monthly coaching to get all those questions answered and provide all that guidance, as well as additional services that include more of my involvement in your case, depending on how much you want. No matter what, if you work with me, you will only ever pay for the help that you need, and all of my fees are going to be flat fee, so you'll know the cost up front. If you're interested in seeing some more of those services where you actually work with me as an attorney, you can check out my website, which is mylifelawyer.com. Again, mylifelawyer.com. Thank you so much for joining today. I hope that going through these factors and illuminating them a little bit more was helpful, so that you know that if you are going to court, or it's likely the court is going to need to make the decision about your parenting time or decision making, you know what they're looking for, so that you can organize and present your case using those factors and giving the court the information that they need to make their decision. Thank you so much for joining. If you would like, I would love for you to come back. I am here every month on the second Wednesday of the month at noon. We're going to continue to go through the process and talk about different aspects of the divorce and custody process in Colorado each month. So do check out next month. And if you want, on the page is also all of the previous months that we have done. So you may find some additional information that you're looking for there. Thank you so much for joining. I hope you have a fantastic day, and I'll see you soon.